guidelines and trying to change some practices, and kind of explain what that looks like. And then I'm going to come back and kind of go through our protocol for visitation, which is on the flash drives that were handed out. And as we're going through the text that's actually there, I'll try to address some of the counterbalancing issues that went back and forth when we were talking about how to implement those. And then we'll kind of talk about what our plans are as far as trying to get this out in our community, because this is only recent. We're kind of at the same point that Judge Stent was at. It's been approved by our local team. We've discussed it with our juvenile judges, and they're on board with it. Now we got to figure out how to get this out to the attorneys and the caseworkers and supervisors and everybody working with these families. And so my name is John Sellers. I'm an attorney in Grand Island. I always tell people my first role is in the juvenile process. I'm a foster parent, and so I kind of see the system from that viewpoint. I'm also a guardian ad litem, parents attorney. I also represent some foster parents as counsel in juvenile cases and help them with subsidy, contact agreement, adoption issues when the children are going to permanency, those types of issues. So kind of working at it from several different angles. KaCee?
I'm KaCee Zimmerman. I'm a supervisor out of the Grand Island office, and currently I do initial assessment, but I've done OJS, ongoing abuse, neglect, adult protective services, pretty much you name it, I've done it. So a couple of years ago, I guess it was 3 years ago, when I was at the Judges Summit, they had these practice policy and briefs, and I picked one up and I started reading it, which if you guys are like me, you go to conferences, you pick all this stuff up, take it back to your office, and it sits in your bag. I actually started reading this, and the thing that surprised me was when they talked about initial phase of visits, that this should last pretty much 4 to 8 weeks. And in this time frame, you should be able to figure out if this family's going to be able to be reunified or what the barriers are. And coming into the system, I've been a supervisor for going on 6 years. We had families that at 6 months were still at supervised visits. And so I read more about this, and I talked to Kelly and said, we need training on this, get people out here, tell us what we're doing wrong. And in this process, I went to a team meeting where we had these kids removed from the home for, it was over a year, and it was just insane. I finally sat down and wrote everything on the board, and I said, why are these kids not home? And everybody said, I don't know. So we made a plan, and we moved the kids home, and we dismissed, and but no one had really thought about it. We just kept dragging it on, and there was no progression. The team meetings weren't productive. And so when we started doing this, that was the reason. There was no progression. We weren't utilizing visitation or parenting time like we were supposed to. We were just caught up in the day-to-day. We weren't talking about it at our team meetings, saying, okay, mom's had unsupervised visits for a month now. What next? No one was saying that. We were just saying, has mom had her drug and alcohol eval? Has mom done this? Has dad done this? We weren't talking about the visits. So I wanted, I guess, the whole purpose of bringing this to Grand Island was I wanted the workers to kind of have a step-by-step. And what Judge Semp showed us, I felt was like a great outline for us. Now, what we did with ours is we kind of plugged in, here's what you do under each of those. So, when everybody has their input, what does that look like? Well, for us, that looks like team meetings every month. Talk about it. What's the barrier? Why is, what are the problems? Things like that. So, everybody's at the table. Everybody can talk about that. And I think also, I guess we think as a team that for a parent to see rewards at every team meeting and say, hey, you've had unsupervised, or you've had supervised visits for a month, they're going well, we're gonna start some unsupervised visits. Now to me as a parent, that would be like, oh yeah. So then, talk about that. Okay, if you do well, then we're gonna add another one. And then the next team meeting, well, your unsupervised visits went well, okay, now we're gonna try all of your visits unsupervised. So they need to see those rewards and those benchmarks to move forward. And then we're not stagnant. We're moving through the system, which is nice. And in Grand Island, we've been lucky enough to have the support of our judges to do pre-adjudication conferences, which is a little different than some of the other counties. We do our first appearance, and the judge gives us 30 days to come back for a pre-trial hearing. Pre-adjudication hearing. And we need to have, what we do is we have a pre-adjudication conference in those 30 days, which is basically a team meeting. And we go in there and we talk about why the family came in. We actually usually read the affidavits and say, we went into the house, mom was smoking crack, there was a crack pipe here, the kids were dirty. We really let the parents know this is why you're here, because we found that some of the parents have no idea why they're there. So we did that, and then we talked about, okay, mom, what do you need? Dad, what do you need? This is a problem. What do you guys need to help you on your feet? What do your kids need? What do visits need to look like? How are they doing in school? Things like that. Who are your supports? So when we have that, that's a great place to start with our visits, because it might be 10 days from removal, maybe 15 days. So we have our initial parenting plan set up, and then at our pre-adjudication conference, we can assess that and say, okay, now we can move to more visits, or they can be unsupervised, things like that. So with us, it's been it's kind of fallen in place because the way we have some of the things already set. So we have a lot of resources that John's going to present here, and I'll kind of throw in stuff, but we had Rose from, I think it's the National Resource Center for Children, come out, and she did an awesome presentation for us. Then we got together as groups and developed a protocol for not only our typical family, but our drug-using, alcohol-using parents, and so we have those two in our protocol. And this isn't perfect, and it might not work for your county or your town, but this is what we're trying and pushing the workers to use, and slowly but surely we're hoping to get this, off the ground. And we wanted to present it today so the lawyers could hear it, and the judges. We presented it, I presented it to our staff, saying this is our expectation, this is what we want to do. And so if John wants to start, we'll kind of give you an idea of what we're trying to have going on in Grand Island.
Great. Picking up with what KaCee was talking about, we've got some Grand Island attorneys and caseworkers and stuff here, and the typical case that we've been used to with a drug problem in the family, children come into care, they're on supervised visits, and at the team meetings we're talking about, well, have you finished treatment? Have you finished aftercare? Have you been clean and sober for 6 months? And we're still on supervised visits the whole time. And so as a team, what we were working on is, if we can get that same drug-addicted parent through that initial treatment and into aftercare where they're working a recovery, shouldn't we be talking about if their ability to safely parent the child has increased as a result of those efforts, then shouldn't we be talking about giving them the opportunity to demonstrate that? And that doesn't mean that we're going completely unsupervised. Maybe we're just, like Norma was talking about, we're putting more distance between the supervisor and the family, or we're backing off and doing drop-ins during a 2-hour visit, or we're finding ways to gradually get the family off of being dependent on us as a team to watch them the whole time they're in contact with their family. It doesn't mean that just because the case has been open for 60 days, that visitation automatically decreases in supervision or automatically increases in frequency. But what we're trying to get people to do is to start talking at the team meetings about supervision is based on safety. If we increase the parent's ability to safely parent, then we should be talking about decreasing the level of supervision to some extent. If the parent is demonstrating an ability to adequately parent during the time and frequency of visitation that we're giving, then we should be talking about increasing that time and duration. Now, if the parent isn't showing up, if the parent isn't coming, if the parent is still actively using and not in recovery, then we're not going to send them on unsupervised visits with the family. Okay, we cannot place the children in that kind of a risk situation. But the idea is we need to change what we're arguing about at the team meeting, because the team meetings, in my experience, have just gotten swamped with visitation as an issue, and we spend an entire hour talking about visits, and we're not getting on to the other things that we need to work on that case. So this is trying to change what we're talking about and giving us some guidelines on what it is that's important to make those two different decisions, which is the level of supervision and the frequency or the amount of visitation. So what we did is we actually created 5 separate documents, and we're kind of putting this as a package. The first one is actually our protocol, our guideline for structuring visitation, and it's kind of a policy statement about what we're expecting with visits. Then Appendix A is a discussion of progressing visits and what that should look like. Appendix B is actually specific age-appropriate, developmentally appropriate guidelines on visitation, just like the Supreme Court has rolled out. But in addition to specifying time, that appendix also specifies appropriate activities, who should be involved, locations that can be used, special considerations within that age. And then Appendix C is the other smaller group that was working on a drug abuse case. What does a case progression look like for a family that's involved with drug issues? And then Appendix D is a roles and function kind of statement. And it goes through every person involved in the case and identifies what are your role in this case, what is your responsibility, what are you supposed to be doing. For example, it goes through the foster parents and says, here's what foster parents can be doing to facilitate visits to help make them more successful. Here's what the caseworker needs to do, the GAL. Everybody is listed, and they have certain roles and responsibilities, because visitation, really, to make it work, you have to have everybody doing their part of that piece of the case. So we defined our parenting time protocol, the purpose to be reinforce the attachments between parent and child and to promote timely reunification. And so these two kind of guiding principles, the first one is really seen in the developmentally appropriate visit, okay? Because what we're really talking about is at certain ages, attachment is much, much more critical, and you need more contact more frequently in a more natural setting, and the parent needs to be actively engaged in caregiving. And so for the earlier children, you see more visitation. If they get older, the frequency of your visitation goes down. The second one, in order to promote timely reunification, up front, we need that assessment phase. We need that information about what's going on so that we can more quickly develop a case plan and get this case going, rather than being 5 months into the case and not knowing what we're working on. When children are removed, a relative or person known to the child will try to be located for placement. If relative placements are not available, the family and foster parent meet at the office to have an icebreaker. biological family will be able to let the foster family know all the information about their children. Now this sounds, like something alien or that's really out there. What I understand from my more experienced foster parents and the people I work with, they've been doing this for years. It's not really a totally alien concept. On the current placement that I have, I went to HHS voluntarily, met with the parent that was having their child removed, found out about shots, found out about medical history, gave that parent some reassurance about, my job is to protect your child and keep them safe in my home, and letting them know that I'm here as part of a team to work with you. I'm not taking an adversarial role with you. And the department has been implementing new procedures to try and identify family and relatives earlier in the case, where they, at the initial intake, they try to sit down with a parent and get any information they can about siblings, about aunts, uncles, grandparents, anybody that might be able to provide care. And then you get to a traditional foster placement if all of that fails. A first visit between parent and child will happen within 72 hours of removal. This has been a commitment on the department to try and get their caseworkers to facilitate getting a service provider in place, getting someone available to do these visits. Now, the other thing that our office has done, and this is voluntarily on their part, they have committed that if they cannot get a service provider to do that initial visit, if they just absolutely say, we're swamped, we don't have anyone available to do it, then the caseworker will try to get that parent and child to the office if necessary to make that initial visit happen. Now, that doesn't mean that we're going to have ongoing caseworker supervising visits, but the local office in KaCee and the administration felt that this first visit was important enough to happen, that if it's a matter of resources and staffing, then the caseworker needs to find a way to make that happen. And if that means the caseworker has to try and get everybody there and do the visit themselves, then that's what they'll do. And I think they've been having really pretty good luck with getting that to happen.
Yeah, we have. I know I had a call a couple months ago, and we were struggling with having visitations. So I just called the foster mom and said, can you come in at 9? The mom came in at 9, and they were able to see each other. And it was, like we said, all removals happen on Thursdays and Fridays. So it was a Thursday, and we got her in on Friday, and they saw each other. The other nice piece about relative placement is you usually can work with the family and say, can mom come over, for an hour every night, or can she, help with supper, things like that. And most of our relative placements have been open to that. So that's a nice piece about that kinship placement is you usually can roll some of this out pretty quickly.
Question.
Sure.
Does it ever happen where the parents could come to school and have one shot? Is that out of the question for the initial visits?
I don't know if anybody's ever asked, but I would think it's fine as long as the school or the school counselor knows mom's coming, things like that. We've had like a soccer game. I always tell parents, go watch the kid play soccer or basketball game. And we're working with the foster parents, and some are not too sure about that, or if it's a non-custodial parent where there's friction between them. But you know what? That's something natural. Let mom stand on the sidelines and watch. So that would be something that we could propose.
One last question, I promise. Removal, you said Thursdays usually happen for Thursday and Friday. It usually doesn't happen any other. What's the reason?
It's just like Murphy's Law. I mean, we can have removal any day, but it just seems like at 4 o'clock Fridays we get those calls, and to try to get a worker to do a visit and all of those things is always difficult. But we do removals every day in the week, unfortunately.
And, and the question about going to the school or something is it safe for the child? Is the first question. And if the child is safe in school, they don't need supervision. They don't need a supervisor from boys and girls home watching them sit in school. Okay. So as long as there's something monitored, okay, we don't, at the initial stage where you have very little information, you don't have very much assessments, you don't know if you're dealing with a mental health problem, you don't know if you're dealing with a drug problem, you know there's something that caused the child to be removed, but you're not sure exactly what the problem is. I would say initially, you're probably going to say that it needs to be monitored. Maybe a teacher or a parent at the school or a member of the administration could be in the lunchroom and just to monitor, to keep an eye on things. You also have to adjust based on the facts of the case. If you're talking about sexual abuse, there's not going to be a visit until you've got, some kind of therapeutic input. If you're talking about emotional abuse, then maybe it does need to be monitored more closely to avoid the recurrence of the emotional abuse. But it's a case-by-case evaluation. If you've got the parent that, they have a domestic disturbance and their kid gets pulled because they both went to jail and that's the only thing you've got, then I would say, yeah, mom could probably go to school and do a visit. So we're not trying to dictate when or what level is appropriate. We're trying to change the language of what we're arguing about when we go to the team meetings or when we talk about this.
And we've been able to utilize, I think they're called healthy starts or early childhood. That's a great time to have a visit, and you don't have to have the visitation person, but your early childhood person is there working with mom and the kid on parenting issues, which we want to happen. So a lot of times we throw that in with our visitation or our parenting time, and so there's extra time to have that face-to-face.
Okay. The next thing that our protocol outlines are the objectives for visitation. As unrestricted as possible based on safety. And then we kind of outline the levels of supervision in a lower section. They should be progressive. Now, I'm going to interject here that I have had a couple of attorneys and some people tell me that progressive means visits have to be increased every time you have a team meeting. And no, that's not a correct statement. The question is, you should be reviewing visits, and if you're being successful at the level you're at, then you should be talking about increasing visits. Not just that you're going to add them every time. We also have to keep in mind that we do have a limited pool of resources of visitation workers, of locations, and those kind of things. So at some point you're going to be transitioning over to informal supports at the school, going to the ball game. Those are all going to be things to increase parent contact time, but not necessarily add to the workload of the visitation workers.
And the HHS workers should be doing like an updated safety plan. So, we have our initial safety plan that says, all these things are happening, it's very restricted. So as the case progresses, they should be able to do that, to be able to look at it and say, okay, you know what, we don't have this safety threat or this safety threat, we can move on.
Then we have developmentally appropriate, which it goes off of the age of the child. And one thing we didn't put in there, we said developmentally appropriate instead of age appropriate, because just because a child is 10 years of age or is 2 years of age doesn't mean that developmentally that's where they're at. If you have an 18 or 24-month-old that is still developmentally not attached and is still showing problems with infant-like behavior, or their development has been delayed because they're premature or something, then you should move them back to that classification and treat visits that way. So the visits need to be based on the developmental age of the child, not necessarily chronological age.
Can we go to appendix B? Just looking at this one. Appendix A, the progression is in this. If you guys have seen the initial, Norma talked about it yesterday, about initial, middle, transitional.
Go to the,
Appendix B. If your workers look at this, and I'm talking about, I mean contractors and HHS, this is, actually, I just think this is really great. It shows the frequency of the visit. It talks about activities, who to attend, what to have at your visits. I mean, this is just somebody who doesn't know a lot about parenting. This is just a nice thing to be able to share with them. And, you know, I just think we have parents, we have 18-year-olds who have babies, and what I hear from the visitation provider is, or the foster parent is, well, they came home, the baby was wet, and the baby was hungry. Well, did the provider say, okay, it's time to feed the baby. Okay, it's time to change the baby. This girl didn't even know how to check a diaper. So we kind of have to back up and say, okay, we have an 18-year-old who was a status offender, and then she went on to be a mom. And so we have to not report the bad things she's doing, but report, we've got to teach her. That's part of our job, is teach her how to check a diaper. I mean, anybody who's a parent has lifted their kid up and smelled the diaper, or stuck their finger in. She had no idea. She didn't know that every couple hours you should check. Or she didn't know, 1 scoop of formula to 4 ounces of water. She didn't know those things. So we as providers need to take that into account and say, just because I know how to do those things, this person doesn't. So let's not judge them on what they don't know, but let's teach them, in order to parent better.
the other objectives, culturally appropriate and in consideration of other factors such as addicted parents, referring to our Appendix C, and or domestic violence issues regarding, if you've got a domestic violence case, you're probably going to have a protection order in place, or it's part of a no contact order and a bond. So then you've got to figure out how to facilitate these visits to go back and forth between the parents if they're not having contact. On our side, on the juvenile side of that situation, we need the parents to try and get back together if they're cooperating, because we need them to be doing visits as a family unit whenever it's safe to do that. And so, when we get the parents that are coming in, if our supervisor can't keep them safe from domestic violence during a supervised visit, then we need a new provider. It's not a parent problem. So if we have supervised visits with 2 parents, even if they have a history of domestic violence, we should be able to keep that child safe in a supervised visit with them together. And that hasn't been our history for a lot of times. We've all had cases where, because it was domestic violence, we insist on having these separate visits, and both parents are parted. And I got one right now 7 months down the road, and dad still can't even go to the house.
And what we need to ask providers too is, if the provider's feeling unsafe, then have it somewhere where they do feel safe. Have it, at the Visinet building where the family can visit, but you have other staff there. Let's try to figure out things that will work. If we don't see any violence in 2 weeks, then let's move it back to their home. But if the provider's not feeling safe, there are some situations where you have providers that, I don't know if I was a provider and, somebody, 2 people have threatened each other, you want to make sure that it's safe for everybody. So just something to think about.
We also set out some guidance, some expectations for documentation. The purpose of documenting visits is in part to be able to assess how the parent is progressing and working on identified issues and on the likelihood of reunification. Documentation will be provided by the provider, and case managers will be responsible for ensuring proper documentation by the provider. Something that has been taking place recently, I think it's Boys and Girls Home, the first one that I saw, that has a visitation plan where they identify like 4 or 5 different goals of what the visitation worker is supposed to be doing. And then each visitation report identifies whether they've been making progress on each one of those identifying tasks. Then as a GAL or a parent's attorney, I can read that report and say, okay, look, they're going to visits, but things are going horrible because they're refusing to accept direction, they're not doing what they're asked to do, they're neglecting the child, they're sitting and watching TV, or parents doing a great job, they're bringing their own diapers and formula, and baby's always being checked, and so those reports are very important to try and assess how effective things are going. And some, that's one of the things. That's why Judge Daniels was raising the question, I think, about where are those reports going to be and how do we get to them, as a judge or as a GAL, so that we can have that information when we're making these decisions.
Something else, right now I know we're going to go to transition with the providers, but for HHS, make sure you have the right service in there, because if you have a visitation provider, I had one tell me the other day that she couldn't intervene. We had a child with medical issues and needed to have insure and things like that. Well, mom was feeding her potato chips and just some things that weren't okay, and she said, well, I can't intervene. So make sure you have family support in there, because they can't intervene. And so you want to make sure you have the right service in there so it's meeting the needs of the family. So just something, sometimes we get in there and you set up, and this is what our authorizations say on the system, so it doesn't say current time yet, it just says visitation, but make sure you have family support provider in there so they can interact with the family from the get-go. We really need that. We don't need somebody to sit and take notes. We need somebody to interact, work on the stuff they need. So
a similar situation that we were talking about when all of this was going on. I was dealing with a case where it was emotional abuse was the reason for the intake, and visitation was put in place, supervised visitation, and I got like 3 calls from that visitation worker as a GAL saying, mom is being really inconsistent on the rules that she's applying. The child, I couldn't even understand what her expectations were. The child was getting really frustrated and angry during the visit. The parent was perpetrating the emotional abuse in front of the provider, and she was saying, I can't intervene in this. You need to get on the stick and have this up to FSP, because somebody needs to slow this down. And so, we need to make sure that the level of supervision we're providing is appropriate to both the intake and what's happening at the visit, and make sure that we have the ability to maintain that level of safety. Question?
Can't a visitation supervision person who isn't a family support worker address safety issues though?
Yeah, but what are the safety issues?
Well,
And I think that's the
emotional
problem
abuse.
is defining what that is, because what some of the workers were telling me is that unless they see the parent about to hit the kid, or they're going to throw them, in a car with no car seat, unless there's an imminent risk of physical harm, they can't really do anything. But I think that's a training issue, and we got to figure out who those people are going to be 4 months from now before we could really address, that level of supervision.
John or KaCee, they're always non-compliant individuals when it comes to documentation. How do you deal with non-compliant providers when it comes to making sure they provide the documentation?
I think those are things that need to be addressed at, probably with the worker and then at the team meeting. So when you're talking about it, can we have a copy of that? Because I think they're always a month, kind of a month, so they can give the summary, and then, we request it. Otherwise, that's something that usually the supervisor might talk to another supervisor about and say, we haven't gotten any documentation, can we take care of that?
But if it's chronic, is this the sort of thing?
I think we continue to talk to them, and then, I might go to Kathleen, and then she might have to talk to somebody, so, you know, we try our hardest. That's why it's important at those team meetings to have the providers so they can tell us what's going on. Some of those things are things we need to work on.
And I think that is a good example of exactly what the presenter was trying to talk about when he was talking about the dispute levels and taking it up the food chain, so to speak. That kind of administrative problem with the services there, but the documentation isn't happening, or we've got a problem with this, then first you talk to the worker. If that doesn't happen, then both sides escalate up their ladder. Obviously, I don't think anybody at Boys and Girls Home is going to, at their administrative level, is going to say, well, we really don't need documentation. So, it is an issue where you're going to have an individual that's going to be non-compliant, or you're not going to get, or a particular group or something. The other thing is our caseworkers in the past have been pretty good about dropping in on visits. And as a GAL, I sometimes drop in on visits as well to give an additional perspective on how those visits are progressing. And I'm hopeful. I don't know that that's going to happen with the case coordinators, but I think that's part of what they're going to be looking at as well. So not only do we want to double check that the documentation is actually getting written down and turned in, but we want it to be somewhat accurate. And then you also get feedback from the foster parents and from other people providing the services on what the child looks like before and after a visit that can also give you indications of how things are going.
With the transition, we probably just need to have a lot of communication that, right now we do service referrals, so it says in case of an emergency or things like that, that's where we need to put, if there's emotional, if mom's not following the rules and visit, or I think we have a comment section. So those are just things that in the process everyone needs to tighten up so we can make sure these kids are safe. But to really express to the worker, to the one providing the one-on-one service, when to end the visit, and a lot of that's just going to be our discussing things and just making sure our ground rules are similar.
Are you going to make sure that this documentation you're getting is going to be disseminated not only to GALs but also to parents' attorneys? Because there's another resource for helping parents understand what the expectations are. But if we don't have it, we don't get it until 6 months down the road, or we don't get it at a team meeting, which I rarely get. I can't help my client or talk to them about changing behaviors in those visitations.
I think we met with some of the, we met, I think, with Boys and Girls and Visitation a while back. And what they talked about is if you call them and say, I would like documentation, they can make sure it's getting to you. That's what we were told. And I think
the other thing that we talked about, and again, we've got this whole new service contract thing that's going. We don't really know how to structure things now. But one of the things that we talked about is, is it even possible to get like a list, just an email list, for a case, that when a visitation worker updates their monthly reports and stuff, if you have kind of opted in, if you want that information, then they can put you on the mail to list and shoot you a copy by email, save the provider the paper postage and all that kind of stuff, get it to you quicker. You can look over that, see if there's something going on. If you want it, fine, print it out, shove it in the file. If it's nothing that's of any use to you and everything looks just peachy, wipe it off the system. And we would have to address some confidentiality issues and make sure that it got to the right location and that kind of thing. But at that discussion that we had, it was something they were open to talk about trying to do, because you're right, as a parent's attorney, if I can confront the parent in my office away from everybody else and say, look, this isn't going to cut it. You're not going to get your kid back this way. You have to follow these guidelines, or you have to get this done. I can sometimes be a lot more persuasive than a caseworker saying, well, we're going to termination next month if you don't get this done. So it is important to try and share that information. Some things that documentation we expected to include: a description of parenting issues presented in the initial stages of the case, identifying what caused the removal, why they're in care, what's causing the problems up front, demonstration of appropriate parenting skills during the visit, assessment of the parent's improvement in addressing the identified issues. Don't just harp on the same 3 things that they don't do consistently at every visit, but at least identify some things that, if they're improving in some areas, let us know that that's happening. And we also wanted some assessment of the likelihood of reunification, an expected date based on improvements that have been documented. And this statement was really more of, asking the service provider that's spending all this time with this family, is this parent getting it? Are they working on it? Do they show an interest in working with their child and trying to get their child back? The things that you can observe in the observation, because that can tell us a lot about whether we're just spinning our wheels, or if we're making some progress and there's some chance that we're going to move forward to a reunification. Visits need to be assessed on a monthly basis. This can either be in person, by phone, or through email. Ongoing assessments will determine when to transition visits to a less restricted alternative. My personal preference is to try and do this at the team meetings, because we try to use the teams in Hall County to discuss visitation, discuss progress on the case, and keep it going. And I think our county attorney and our judges have that expectation. They're kind of depending on us to manage the cases from this teamwork approach, and it's worked relatively well. So we can share information, we talk about it, and if we need to make changes in between, we can. But basically, what our practice has been is to review visitation at the team meetings and to try to make changes for the upcoming month.
And I think with the team meetings, we just, I've heard some people say, well, I wasn't invited. I think everybody has to, call the worker or call the GAL. When's the next team meeting? Because what they try to do is have that team meeting, and then while everybody's there, schedule the next one. And it's really important too to have your ground rules there, that everybody's honest, because sometimes at your team meetings, you walk out the door and the provider will say, well, Mom wasn't doing this, and it's like, oh my gosh, you gotta say it in there. And they're afraid to damage their relationship with the parent when they're doing their parenting time, family support. So we really have to make sure everybody has that rapport to say, you know what, Mom, I want to make sure the kids go home, you're safe, but I'm going to have to be honest to the team so we can work on these barriers and we can put services in place. It's got to be that approach, because when you walk out the door and you've said, okay, we're going to have 3 unsupervised visits, you walk out the door and somebody says, well, Mom was doing it, that's counterproductive. So we have to really make sure we're addressing those issues and going around the table saying, is everybody sure they're okay with this, with the safety plan, with the other things that are going on? So really attend those meetings if you can, because they're very important, and they're going to be huge with our transition, because we're going to have our service coordinators, we're going to have our case managers, we're going to have all these different folks, and so that's going to be where we share all that information and get caught up with everything.
Just a semantics thing, would you say at the minimum it's a monthly team meeting? Because it seems like just in common practice with those babies, or when you have the big sibling strips, or it's a combination case where there's abuse, neglect, and a delinquency case, and maybe a status offender, that those team meetings are occurring maybe every 2 weeks to kind of get that moving along at the beginning of the case, or if Mom just got out of treatment and is being integrated back into the community.
I would say that we typically have been doing a monthly team meeting, but early in the case, as KaCee said, we're doing a pre-adjudication conference less than 30 days after the removal. So that's really the first time the whole team gets together to talk about whether there's going to be an admission, what what the services are gonna look like, try to come up with a case plan, and discuss visitation. We will normally, if that happens, then we're having a pre-adjudication hearing in 30 to 45 days. So we're all back in court together to, enter that plea or make an admission of no contest or whatever's gonna happen. If we have the case plan at that time, we'll go straight to disposition at that time and get the case plan adopted. So it is possible in the first 45 days that we've had one meeting and one hearing, all within 5 weeks of getting removed. And then we will try to, if it goes forward to disposition hearing, usually we try to set a team meeting in between the pre-adjudication hearing and that next disposition, so that there's an additional team meeting to present a case plan or talk about the case plan before we try to get back to court. Now, it doesn't happen all the time, but I don't think, at least I haven't been on a case where the attorneys were even available to really get together every 2 weeks on a consistent basis.
Well, and I guess I'm a full, huge team meeting with everybody, but just with the service provider, the person that's doing the parenting time or supervising that parenting time, the caseworker, and soon to be the service coordinator, to just iron out all those little things and mom things.
Oh, they're having a lot more
It
frequent.
seems like that's happening more and more in our
And I think some of
area.
it's case specific. I went to a team meeting the other day, and actually the day before, Dad went to jail on some pretty severe charges. So we all came together and we met, and then we met 2 weeks later just because then Mom was going to court, she was incarcerated. So I think case by case, as those bumps in the roads or barriers come up, yeah, I think we're meeting more often. And hopefully the workers are recognizing that and saying, you know what, we all need to pull together. Or if you hear 10 stories, it's always good to get together and just say, let's all get on the same page. So I think they are. It's some workers think it's too much work. I encourage my worker that I think the more we meet, or if you have your monthly team meetings, you're gonna have less work in the long run because everybody knows what's going on. So I think it's just the department and the contractors encouraging our workers to have more of those contacts and how important those team meetings are.
The other thing I'd add to that is, I don't know that making adjustments to visitation every 2 weeks is going to be very productive or helpful, because 2 week slice out of visitation is not going to give you very much of a picture of what's really going on. And so I guess my perspective from being a GAL is I'd really like if we increase visits, we're going to talk about, like with infants, we'll go through kind of what our protocol would be. If you're going 5 days a week and you're doing an hour or 2 hours each visit, 10 hours of supervised visit, I would really like to see that 30 days of the parent consistently showing up and being able to do the parenting piece, be able to know when the baby is dirty and needs to be changed and that kind of stuff before jumping on trying to adjust the visits. But I do think that there needs to be more frequent contact between the visit worker and the caseworker, or whoever's going to be doing that function, because they need to have that back and forth dialogue about what's going on and what concerns they see and that kind of stuff.
Sometimes after that initial period too, you can have the flexibility, like John said, if it's 5 days, 1 hour each, at your team meeting, you can say, if things are going well, is everybody okay if we increase it an hour? So in the next 30 days, then the team has the flexibility to do that. So, and usually the worker will just send out a note saying, things are going well, we increased another hour for another day.
The other thing that we put in there was the safety issue, and basically we wanted it very clear that no visit that's being provided in one of these cases cannot be terminated for for a safety issue. We want it up front as part of the policy that if there is a safety concern during that visit, that provider needs to bring it to a halt or reduce that safety threat in some way. And I don't think anybody disagrees with that as an idea, but we do need to figure out what the perception is of the people that are on the front line. You know, and as our new providers get on board with providing more of those services, you know, clarifying exactly what they're doing. We've also talked about meeting up front, identifying if a case is an emotional abuse case or if a case is a sexual abuse case. And there's going to be some kind of contact, giving some specific guidelines to the visit worker that says, okay, these are the things that we're really worried about, and if you see this, this, or this, it stops. And then you just call me and say, you know, I had to end the visit, here's what mom and dad are doing, or whatever.
I heard somebody talk at one of our breakout sessions about UAing parents, and I know when I started, you did a UA on Monday, and if it was dirty, we weren't having visits. We're not doing that anymore. They're having the visits. We are UAing them randomly, but they're supervised, things like that. That's really stressful on all parties. Not only you have a worker who's set aside time to do the visit, you have a kid who's expecting a visit, a parent who's expecting a visit, and if they come in and pee on Monday and don't have their visits all week, we're just trying to look at that different. We are, though, addressing if they, you know, if it's a positive UA, then we are addressing that at our team meeting. That, you know what, Mom? You've had 2 weeks of visits, you've had UAs all those times, and you have been, you know, dirty the whole time. So really, what do you have to do? You can keep doing visits, but really we're looking at, is reunification really a possibility? So it's something that's still addressed.
We also set up Appendix D to define those roles. I talked about what each person involved in the case, what their function is. That's going to be part of trying to figure out how to get the attorneys together, how to get caseworkers together, supervisors, and share some of that information. Then we kind of specified the levels of supervision, and we're going to use different labels, and we're going to have to figure out what all of those are going to be. But we basically talked about therapeutic, we talked about supervised, and I think that at supervised level, what we're thinking of is a paid provider supervising and ensuring safety. Because then when we get, we have an observed, monitored, there's some kind of contact. Do what?
So I think Norma called them drive-bys.
Yeah. When we, the third level, we call observed and monitored, and that's where you can do Norma's drive-by. That's where you can have the drop-in visits. That's where you can have the relatives providing more of the contact supervision in a more family-like setting. If you get to this point, then that means that you don't have a safety concern. Basically, the safety risk is down. We just want to make sure that things are staying that way, and we're kind of monitoring to ensure that things keep going. And then we get down to unsupervised. And so these stages should progress as the case progresses. If you go to court and the judge says, "How is this case going?" and you're, you know, it's a review hearing and you're 8 months after removal, and you say, "Well, we're at partially supervised with some drop-in, and we're doing 5 days a week, an hour a day," the judge should say, "Then why are we still here?" Because if we're 8 months into this case and you're still supervising, we've got safety concerns that still exist, and we're not transitioning this case anywhere, and we're now 8 months into it. And certainly at that second review hearing, when you're 12 months down, if you're still supervising at that point, you're done. I mean, that should basically, your visitation and level and the frequency, duration, where they're happening should reflect where the case is at, because you should be assessing the case and the safety level and the ability of the parent ongoing, month to month. And as a team, you're basically progressing the case and recommending, you know, an outcome when you're deciding the visitation. That's a totally different approach than what we've had in before, where, you know, I have sat in a lot of team meetings and even advocated for not increasing visits until the case plan was done, or not moving the kids back into the home until the case plan was done, plus 3 months of observing clean and sober, you know. And so I'm reprogramming myself to try and get out of that, and it's not real easy. We also put in there sibling visitation needs to happen on a regular basis. If at all possible, try and get them together on a weekly basis. Unless distance or travel or behaviors or something are giving us a good reason not to do that, we'd really like to have the kids together.
And ask foster parents, a lot of times they'll get them together, or you can place kids with foster parents that are friends, and that works really well. KaCees have helped us have those visits, so those are things to think about.
All right, we're almost out of time, so I was going to hit on a couple of things. Looking at our model, birth to 18 months, we would be advocating for 2 to 5 visits per week, a minimum of 60 minutes each. Consistency in the schedule is important, and once or more a week with any siblings the infant doesn't live with. And then coordination with the caregiver and parent to keep the child on the same eating, sleeping schedule, so that we're not totally turning the kid upside down every time they transition back and forth. Contact activities with frequent face-to-face as possible. Pictures, parents' voice recorded, video, parent clothing, items with their scent, etc. Those are things that come from our psychologists that tell us that you can enhance the visitation and ensure safety by using some of those transition items. Prefer that it be in the home or a home-like environment. You know, trying to get a baby to take a nap in the front room at Visitation was just virtually impossible. Traffic in and out, noise, bright lights, no crib. You know, it just wasn't really going to work. We want the parents to provide for normal infant care, and other locations and contacts can occur, including doctor appointments, child care location, family events, religious activities, etc. Then we went through and tried to identify at each developmental stage for the children, we tried to identify some things the parents should be doing. The focus here was on trying to, you know, what does a parent should be doing with an 18-month-old or with a 12-month-old, trying to get them to engage with their kids. In the team meetings, I try to tell my parents, you know, come to every visit with a 30-minute activity plan that's appropriate for your child, and tell your visit worker what you're doing. Just think ahead about something to do with your child. And then we talk about the specific level of supervision at that developmental age, what the considerations are. You know, obviously with an infant, the biggest one is they can't talk, they can't tell you what happened, they can't tell you if something goes wrong or what they need. So you have to have a higher level of care than maybe you would for the high school student. Try to limit the number of people transporting, supervising, handling. I mean, our current case, we got 2 parents. I've had 8 workers on one, 5 on the other one, and 3 case workers who have all been transporting a child under the age of 16 months. And that's been over the course of about a 15-month period. So, you know, we've had this rapid turnover and lots of people becoming involved. Then who's attending, trying to identify who should be at the visits. You know, this is just a guideline to talk about visits. We're not really trying to dictate what they're going to be, but trying to give some guidelines and improve some of that.
And this is working for us, and if you guys want to look on your flash drive, all of our appendix are there. And one, which is really good, is roles and responsibilities. It talks about the parents, the worker, the foster parent. It even talks about the person transporting. What you can do before, during, and after the visit to help the child. So this is, I mean, this is some great stuff. So make sure you look at it and pass it on to your workers just so they can start reading over it and then figure out what works for you guys. Thanks